Good morning, everyone. Who's got questions?
Did you speak to the jury?
I spoke to some of the jurors.
What's the impression you got?
I think that they were deadlocked early, and it wasn't really something that there was a lot of back and forth. I do think they deliberated and thought about all the issues. It sounds like they listened closely. I thought it was a very good jury of people that were put in a very difficult situation. And so, they did their job. And sometimes this happens where you can't get 12 people off the street to agree as to a very important decision. So I thanked them for all the work they did. Some of them were willing to talk to us. And so my sense is that they worked very hard to come to a conclusion, and sometimes you just can't.
Can you talk about the reaction from Christopher Schurr?
He's been living with this for 3 years. He obviously wanted some resolution. I think he felt that the jury took the time to deliberate, and he appreciates that. He obviously wanted it to be done, but it's a hung jury. So I haven't had much chance, obviously, to talk to him yet because I've been talking to the jurors. So, he'll probably have to reflect on it, as we all will, and as will Mr. Becker, on how we proceed next.
What do you think about the possibility of a retrial? I mean, what do you think should happen?
I do not think this case should be retried. I don't think it should have been charged in the first place. I think that it was clear, based on the evidence, that there wasn't enough to establish a charge in this case. I think there was a lot of evidence at trial that was irrelevant and that shouldn't come in. And so if there is going to be another trial, we're going to likely seek rulings from appellate courts as to what evidence is put before the jury. In particular, I do not believe that this theory that was sponsored by Professor Stoughton, how an officer can put himself in jeopardy by following what he believes to be poor policies of GRPD, where he loses the right to defend himself should he later be put in a position where someone is about to use, he's an imminent threat of bodily harm or death. I think that's absolutely wrong. I think the jury was confused by the fact that the prosecutor was saying that he cannot defend himself because he screwed up on whether or not he should chase him. I think that had effect on the outcome and the fact that they couldn't reach a unanimous verdict. And so if there is going to be another trial, we're going to be asking the Court of Appeals to decide whether officer-created jeopardy is something that should apply in a criminal case, and whether officers, if they make any negligent act early on, they can no longer defend themselves if someone turns on them with a dangerous weapon.
Were there a number of appealable issues that you saw during this trial?
Yes.
Can you talk about those, other than what you just spoke of?
Substantively, that's the main issue. And, to those that are following legal opinions, there was a U.S. Supreme Court case just in the last 6 months called Barnes v. Felix, where this exact issue was argued extensively. I think that, this officer-created jeopardy is incredibly dangerous, not only for police officers who are asked to put themselves in dangerous positions, but for the community. Because what's going to happen if you instruct officers that they cannot arrest somebody, and it's up to the person being arrested to decide whether they're not going to be arrested, you're going to see a lot of officers who are going to hold back and be instructed that if later on this person has a gun or gets a dangerous weapon and uses it on me, I can no longer defend myself because I've screwed something up early on. So that's the primary appeal issue. We, as you know, Mr. Coker, we briefed that extensively before the trial. We tried to exclude it all for the trial, but yet it became the central issue. It's clear to me, and if you listen to the prosecutor's closing statement, that he talked about the chase and whether or not that was reasonable, when the issue should have been whether at the moment of the threat, whether Christopher Schurr was in fear of great bodily harm or death, and whether he acted as a reasonable officer would in that situation. So that's,
Sorry.
go ahead, Duncan, right? Okay. Sam, sorry.
The decision for Schurr to testify, how and when was that made?
We anticipated he would testify, and, you know, as we saw the proofs come in, we felt that it was important for the jury to hear from him, because, you know, it's a case where what he was thinking, what he was feeling is important. And while there were plenty of experts on both sides to talk about whether it was reasonable, the only person that could say what was in his head is Chris. And, you know, it was a matter of, well, if something happens where he shouldn't testify, we won't have him testify. But the plan was he was going to testify unless something happened.
Did you know how that played with the jury? Did you spoke to the jury about his testimony, what difference that made at all?
I think they considered it. I don't think anybody thought he was dishonest in his testimony. Obviously, we didn't talk to a lot of the jurors, and I'm not going to get into specifics of what they're telling us, but I think it played a role, but wasn't the dispositive witness.
You can't tell us how close they were one way or the other with it. Was it 11-1 one way, another way, you know, half, 50-50? Can you talk about that?
It was overwhelmingly in favor of acquittal, and there were holdouts on the other side.
How many holdouts?
I don't know for sure.
How long were you talking to the jury after the mistrial was declared?
I don't know, from the mistrial until I came down here. I don't know how long that was.
During close, you had mentioned that you didn't have to put on a defense, but you did because of the importance of the case. Moving forward, should this be retried again, are there different approaches that you may take? I know you can't get too much into strategy, but were there things that you left out this time that maybe you think next time would be appropriate to bring in?
It's kind of speculative. I don't know. It would depend on what the trial looks like going forward. I mean, if we're arguing about whether or not he was negligent in chasing him, then I'm going to have to address that again. I just don't think that should have been ever put before the jury, and because it came down to whether or not GRPD's policy or no policy on foot pursuits had some sort of bearing on whether or not he can use deadly force to protect himself. And I mean, I think over half the trial was about irrelevant evidence. You had experts on both sides talking about how close you can stand to somebody when they deploy their taser. I don't know how that relates to a minute and a half later when Mr. Loya has exclusive control of the taser and is turning. It shouldn't matter. I was flummoxed by the fact that an expert can get on the stand and say, because you're too close, Mr. Loya grabbed the taser. That was a decision that was made by the individuals that were in that situation, and not because of some GRPD policy.
Matt, you asked for a mistrial on that count 3 times, maybe it was 2.5. The judge then said you put something in motion by rolling her eyes. What did you think of the judge in this case? And was this a fair trial? You keep asking for a mistrial. Was it ultimately fair? Did she do a good job?
We asked for a mistrial, and the primary reason was because there was all this evidence put before the jury that we did not think was relevant, and that was the focus of the prosecution's case. As far as the allegations of facial expressions, we obviously don't make those allegations unless we're certain that they're occurring. It was a crowded courtroom. It was our belief that the judge had been communicating with the jury. Why she might be biased, we never suggested one way or the other. We just thought that her demeanor at times suggested that she had feelings about something that coincided with the testimony.
So someone on your defense team actually saw her rolling her eyes, is that what you're saying?
Yes.
How many times? Could you talk, was it often, was it frequent, one time?
Throughout the trial, we thought there were facial expressions and didn't raise it. And then when Officer Schurr testified, we believe that there were facial expressions that were communicating something to the jury, and that's why we filed the motion.
Sorry,
Yes.
sorry to interrupt you. When you said earlier that the jury was in favor of acquittal, do you mean acquittal on the second-degree murder charge or voluntary manslaughter or both?
Both.
And you don't know the split of it?
The split goes back and forth. It just, it was communicated that it was, there was always a majority for acquittal on both. And I don't know whether or not, this is probably your next question, they all agreed to acquit on second-degree murder or not. That wasn't communicated to us one way or the other. When I asked before the mistrial was declared, I was asking for the judge to ask the jury whether they could, if they had reached unanimity as to count one, which was murder in the second degree, and she declined. She's not required to do that under the rules, but if they had reached a verdict on murder 2, then jeopardy would have attached and there wouldn't have been a retrial.
Did you get a sense among the jurors that it mattered that 2 of them had relationships with police officers? One was dating a police officer, one had a grandfather who was shot in the leg. Did that matter at all?
That didn't come up, no one said, yeah. I mean, I thought that the jury did a great job of setting aside any biases or prejudices they might have one way or the other. A lot of us know police officers. It doesn't matter where you're on the political spectrum. And in my experience, most people respect police officers for the difficult job they have to do. But I don't think it weighed in their decision. And I didn't ask them, and nobody said anything.
You left a number of challenges in your pocket during jury selection. What made you feel like the jury that you had was the best one you could get?
It's always tough. I heard Mr. Becker's response. I felt it was a fair jury, and we were looking for people who would say that they're open-minded, that they hadn't really followed the case, that they didn't feel strongly one way or the other about police in general or other sort of important political issues. And I think we had that jury. You never know who's coming up next. And when you run out of that last peremptory, then you can't get rid of somebody if you get someone who isn't open-minded or for either side. So it's not unusual for me, at least as a trial attorney, to have a few peremptories left. I tend to believe that most people are going to be fair-minded. And talking to the jurors, they really were. They listened to all the evidence, and they considered it over the course of days. So, what could have happened if I'd used more peremptories? I don't know.
So if this case gets tried again, would you ask for a change of venue?
That depends. If we don't think we can get a fair trial here, we would consider that.
If it was a majority for acquittal, do you think that should come into play when Prosecutor Becker is reconsidering retrying this? And is that something?
I think he should consider that. I mean, what better litmus test for whether or not something should be charged if whether or not he can prove it beyond a reasonable doubt. And I think as a former prosecutor myself, certainly you could say, oh, there's probable cause to charge, but the standard should be, do I think I can prove this beyond a reasonable doubt? And now we've gone through a test run, which frankly the evidence I thought was in favor of the prosecution in the way it was let in. I think, I hope that Mr. Becker considers that partial judgment when deciding whether to move forward. And we don't think he should.
Do you take this as a victory? I mean, how do you take this?
This is not winners and losers in this case. I mean, Christopher Schurr never wanted to take a life. I guarantee it, he is the nicest man. And this was the most difficult thing he's ever had to deal with. That decision in that split second. And we cannot declare victory because there really is no winning here. A man died, and that is a very serious thing. Christopher Schurr is happy that the jury didn't determine that he's criminally responsible for that death. But, it's hard to say that we feel like this was a victory.
Has Christopher Schurr said anything about his future plans now that this trial is?
I don't think he's had a chance to think about it. Obviously, there's a lot of things that could happen. I mean, he's working. He's got a lovely wife and family. I think he's probably going to continue with the status quo, and see how things unfold. But he's a pretty even keel person. You saw him testify. That is his personality. He doesn't like talking in public, but understood he had to. And going forward, I'm sure he's going to reflect. He'll probably pray on it and figure out whether he wants to change jobs or anything like that. But
Did Mr. Schurr ever talk to you about how he felt about the crowd of supporters and protesters that would greet him every morning?
I didn't really have any conversations with it. I know the family, and I know Chris appreciated all the support for law enforcement in general. He recognized and respected the fact that everybody can have opinions and is willing to, he was more than willing to listen to people who are against his position. So he's just not the type that's he's not a very political guy. And so he was more focused on the case itself. So, we wanted to focus the jury too on the actual issues and not the greater issue of policing in America and in Grand Rapids and specifically, because those are important issues. But what was at issue here was whether or not he could use deadly force in that situation.
Matt, at this point, the video that the public has seen for the last 3 years is maybe a little different than the view you provided in court with your forensic video analyst, specifically on Patrick's hands. We've all been saying that there was a struggle over the taser. You showed that close-up view showing that Patrick had the taser, as Christopher said. Do you think it's important for the public to see that view, and do you think that changes, outside of the court, how he's viewed and how his life is lived with that view in mind?
I think that what the trial can do, because it's a public proceeding and you can all see the evidence now, is it can address some of the misinformation that was provided to the media early on, especially about Mr. Leolia's background or what he was doing that day. I think it's great that people recognize now that it's clear that Mr. Leolia had it in his hand. Now, how he had it, I guess you could debate that. But yeah, I think it's important for the public to know. What was more important is to get it before the jury and let them decide, and hope that they didn't consider any prior misinformation that was out there.
Will you be at all in contact with Prosecutor Becker as he makes his decision whether or not to retry the case?
If he's willing to talk, yes. I've known him for many years. Obviously, we have some input, and if he's willing to talk to us, we'll talk to him.
Can you talk about whether the jury, obviously they watched the video, it's a gunshot to the back of the head, and how difficult, or whatever, to get around the optics, the gun to the back of the head?
I don't think it played any role in their deliberations, and the reason is because as the evidence came in, even the prosecution's experts acknowledged that the location of the deadly force is absolutely irrelevant. And this is one of the things where attorneys for the Leola family, I think, have spread information that is not legally relevant. Sure, optically it looks bad, but I don't think the jury even considered, because Seth Stoughton and Mr. Bloomfield, experts for the prosecution, agree that it's the decision to use deadly force and whether that is reasonable, not where you shoot somebody. And it's terrible that it's the back of the head optically. I get that, but it's legally irrelevant. And I don't think the jury even considered it. I didn't hear one person even bring it up.
Matt, you wanted to bring up Leolia's criminal history and past leading up to this incident. Is that something that you think would be important to bring to a jury in a future potential new trial?
The issue was whether or not what was in Christopher Schurr's head, what was in his knowledge. And the reason the defense was going to bring that up is because, in large part, the prosecution was going to bring it up first. And so we wanted the opportunity to rebut that. And we also wanted to explain why he was fleeing and why he was fighting so hard. I think that is from a jury's perspective. I don't know that it matters that much. It really matters what Officer Schurr knew. And so You know, if we have to do this again, whether we're going to have those similar rulings, I don't know. I was also troubled by the fact that the prosecution's experts focused on the intent of Mr. Leoya without us having the opportunity to explain why we think his intent might have been different what they were saying. They consistently suggested and put evidence that, you know, he intended to look at the noise in his car. Where we were going to argue that based on evidence that we had and wanted to put in front of the jury, his intent wasn't to go look at as to whether or not there was something wrong with his car. His intent was to immediately run away, but the officer was on top of him. So those sort of things didn't come in. I don't know in the future what we'll try to put in or not. A lot of it's going to depend on what the prosecution's case is.
Should Mr. Becker decide to retry this case, do you think the time that has passed since April 2022 plays an impact, you know, in just the terms of maybe potential jury selection or the, I don't want to say freshness, but like the kind of the overall time period that has passed since the initial incident?
I think that's a good question, and that, you know, the prosecutor always considers what the community standards are at that time. I mean, things change over time with regard to whether police should act in a certain way. That might come into his decision. Ultimately, that's Mr. Becker's decision. Obviously, you know our opinion on whether he should charge it, whether it was 2022 or 2025. We don't think he should. But, you know, these are important questions, too. I just hope that if we have another trial, it is not about the greater, maybe more important picture or a question of whether or not GRPD should chase somebody, whether or not their policies are consistent with community standards. A criminal trial for murder should never be about broader, very important questions about policy. And that's why we think this case shouldn't have been tried. If we were, because that's not what this case is about, but it became that. And so if we're going to do that again, I think it'll be error once again.
The FOP Lodge put out a statement just a little while ago saying that the fact that charges were brought at all was because of public pressure. Can you talk about, what's your response to that?
I mean, it's up to Mr. Becker to decide what he wants to do. You know, he's the one that has to make these decisions. They're tough decisions. Whether he succumbed to pressure, you're going to have to ask Mr. Becker. I mean, I have my opinion as a former prosecutor whether it should have been charged in the first place. I don't think it should. You know, we offered to talk to Mr. Becker before it was charged. There were some limited discussions, but we didn't have much input on that, so you'd have to ask Mr. Becker.
What's your confidence level, given the time that's passed and what we saw today happen, that if this were retried, whether or not there would be an acquittal as opposed to yet another hung jury or even a guilty verdict?
I thought we were going to win the first time around, so obviously I feel even stronger that we would win should we have to retry it.